Hi everyone. In this segment of IP Explained, I'm going to dispel 5 common copyright myths I often come across in my practice. The first myth is if you pay someone to create a copyright work, like a graphic designer for a website or a photographer to take photographs for your business or events, that you own the copyright. The law of Canadian copyright is that unless there's an agreement or there's an employment relationship, it's actually the author, creator, or photographer who owns the copyright. As the purchaser, you actually only obtain a limited license to use the resulting work that you purchased, but don't have any ownership over copyright and may only have limited, if any, rights to use, alter, or further reproduce the works that you've purchased. This is a significant difference from the copyright law in the United States. The second myth is that as long as you include the author or artist's name and attribute the work to them, you can produce or use someone's copyright protected work. This is also incorrect. It's actually the author or artist's prerogative whether or not they want to be attributed to their work. So you could be further infringing not only their copyright by reproducing or displaying part of their work, but also infringing a separate aspect of copyright called moral rights by attributing the work to them when they don't want the attribution, because after all, it is their prerogative. A third myth is that as long as you don't use or copy the entirety of a work, for instance, you only use part of a song, book, or movie, it's not copyright infringement. In fact, copyright infringement occurs where a substantial part of a work is copied. There's no clearly defined quantitative rule, threshold, or percentage. It's a qualitative analysis that the court applies. In some cases, even a line of a song could be copyright infringement if it's the most important, recognizable part. A fourth myth is that as long as something is publicly available, it's in the public domain and free to be used or copied. Something being publicly available has no bearing on whether or not it's considered to be in the public domain and therefore available to be used. Works only end up in the public domain if the author or creator has expressly given them to the public domain, which is extremely rare, or if the author or creator has been dead for over 70 years. Otherwise, the fact that something is available online or elsewhere does not mean it's in the public domain, and using it would be copyright infringement without consent or permission. The fifth myth is that copyright only exists where it's been formally registered. In several countries, including Canada, there is a formal government registry where copyright can be registered, but it's not the case that it must be registered in order to have copyright protection. It does provide some added benefits to seek registration, and it's a very cost and time effective thing to do, but the fact remains that putting something into fixed form, pen to paper, finger to keyboard, paintbrush to canvas, as the case may be, does provide copyright protection, and copyright starts as of the moment it is in fixed form. Because of that fact, and the fact a lot of people don't realize that that's the case, I always advise clients to put a copyright notice on their works. Typically that includes the C with the circle around it, which is the copyright indicator, with the year that the work has become published or publicly available, and a comment to the effect, all rights reserved. This can be a deterrent that eliminates or mitigates the risk of potential copyright infringement, which is something I recommend and is quite an easy solution. If you have any questions about copyright or need any help ensuring that your intellectual property is adequately protected, reach out to Field Law and we would be happy to help. Copyright is another one of those areas where an ounce of prevention is worth a pound of cure.